I've been waiting for this moment my entire career." The courtroom went silent as Representative Jasmine Crockett stood before Judge Emmet Sullivan, pulling a sealed packet from her briefcase. The judge, known for his tough questions and direct approach to evidence, had just spent the last few minutes challenging Crockett's claims of government misconduct. "Representative," Sullivan said with the seriousness of his years on the bench, "these are serious charges against government officials. I need more than just your word that these documents are real." The packed courtroom watched as Sullivan leaned forward, peering over his glasses with a look that lawyers in D.C. knew well. "In my court, evidence speaks louder than political speeches." That's when Crockett, herself a former trial lawyer, pulled out the packet no one knew she had. "Your Honor, this evidence was obtained through a FOIA request my office filed 6 months ago. The Justice Department fought its release, but the appeals court ruled in our favor last week." As Sullivan examined the first document, his expression changed from legal skepticism to utter shock. The gavel in his hand stopped midair. For perhaps the first time in his long career, Judge Emmet Sullivan seemed speechless. This wasn't just another political hearing or government show. This was a former defense attorney presenting evidence that even one of the nation's strictest judges couldn't deny. Before we reveal what was in those documents and how this amazing courtroom moment could change government accountability forever, please hit that subscribe button and turn on notifications. Our network brings you the crucial battles between power and truth that mainstream media often misses or distorts. To understand the full meaning of this courtroom showdown, we need to look at who these two judicial masterminds are and what brought them face to face in this tense legal fight. Emmet Sullivan is more than just a magistrate. At 77, he's been a judge on the U.S. District Court for D.C. since 1994, after being on the D.C. Higher Court and Appeals Court. What makes Sullivan really special? He was chosen by leaders from both the Republican and Democratic parties, Reagan, Bush Sr., and Clinton. This shows how much he's respected for being fair and knowing the law, no matter who's in charge. For about 30 years, Sullivan has been known as a very independent judge who isn't scared to stand up to powerful groups. In 2008, he was in charge of the corruption case of U.S. Senator Ted Stevens. He ended up dismissing the decision because prosecutors did not act appropriately. In 2014, he told the IRS to explain how they lost emails that were important to a lawsuit about targeting conservative groups. And in 2017, he ordered the State Department to look for more documents about Hillary Clinton's email use. Sullivan said in a speech last year that our legal system needs judges who are ready to point out bad behavior no matter which political group is winning. He added that as soon as we let politics get in the way of our choices, we don't deserve to be judges anymore. Sullivan's way of judging shows he cares more about the truth than politics. He asks tough questions to both sides, demands solid proof instead of political talking points, and gets annoyed with lawyers who seem unprepared or try to trick the court. People who watch the courts closely have noticed that Sullivan is usually as strict with government accusers as he is with defense lawyers. He focuses on how good the legal arguments are, not who is making them. Sullivan's life story has really shaped how he approaches things as a judge. Growing up in D.C. with a cop dad and an admin mom, he worked hard to get through Howard University and its law school. Seeing the inequalities in the justice system while growing up in a divided city gave him a unique point of view. Plus, his dad being in law enforcement taught him to respect the law. Because of all this, he's really aware of both government overreach and how important it is for organizations to be honest. On the other side, you've got Representative Jasmine Crockett from Texas. At 43, she brings a totally different background to the table, but one that's also grounded in working with the law. Before she got into politics, Crockett made a name for herself as a civil rights attorney and advocate in Texas, standing up for people who often didn't have a voice. After law school at the University of Houston, she started out doing criminal defense, handling everything from small stuff to death penalty cases. She's been through over 100 jury trials. All that hands-on work helped her understand how laws really affect people, especially those who are often left out. Crockett once said that when you're in court, your political ties don't matter as much as being prepared. She learned fast that judges respect lawyers who know their stuff, can pull up relevant cases from memory, and never show up unprepared. Before she got into politics, Crockett worked in the Texas Assembly. There, she quickly became known as someone who really pushed for changes to make the law system fairer, protect voting rights, and make the government more see-through. Her background as a judge was super useful when she was trying to write new laws and get people from different sides to work together. What makes Crockett different from other politicians who used to be judges is that she still gets involved in big cases. Unlike some people who just see their law background as a plus, Crockett has stayed part of the law world. She sometimes writes friend of court briefs and gives advice on rights cases, even while she's been in the legislature. The reason these two law-minded people ended up disagreeing was because Crockett started looking into some national groups for possible wrongdoing. After people told her staff that files were being destroyed and proof was being changed, Crockett's team started sending requests for information to different departments. When they kept getting turned down or put off, Crockett did something unusual. She sued the groups in court. The case ended up with Judge Sullivan, which a lot of people thought was bad luck for Crockett because Sullivan wasn't known for liking cases that seemed like they were politically driven. Law experts thought Sullivan would quickly throw out the case because it seemed like a political investigation without good proof. This disagreement happened during the first meeting to decide if Crockett's case should go further. The law department asked for the case to be dismissed, saying that Crockett didn't have the right as a legislature member to start a case like this and that her claims were mostly guesses. Sullivan set up the hearing to check out these claims and see if it was worth keeping going. That day, the courtroom was unusually full. You had reporters next to legislative staff, government lawyers on one side, and community groups on the other. Even some former judges came to watch, knowing this case could set a big precedent for how Congress oversees the executive branch and how the courts review it. What do you think about officials suing government groups? Does it make them more accountable, or is it just political theater? Share your thoughts below. We especially want to hear from people who've worked in the courts or government. The tension in Courtroom 24A of the E. Barrett Prettyman Courthouse had been building all morning. The government's lawyers argued for dismissing the case with the self-assurance that comes from representing the full power of the legal division. They pointed to past cases that limited Congress's ability to sue government groups, and hinted that Crockett was just trying to make a political statement instead of doing real oversight. When it was Crockett's turn to present her case, many expected the kind of passionate but legally flimsy arguments you often see when governors show up in court. Judge Sullivan, known for cutting through the BS and demanding facts, had intimidated even the most seasoned Department of Justice lawyers in the past. After the morning break, Sullivan called the court back to order, adjusting his glasses. As he looked at his notes, the courtroom went silent. Representative Crockett, Sullivan began, his deep voice filling the room. Before we go on with your arguments, I have some questions about the basis for your claims. Crockett stood up from her spot at the plaintiff's table. Unlike many governors who hire lawyers to speak for them, she had decided to argue her own case, a move that raised eyebrows among the court watchers. I'm ready for your questions, she said, sounding calm and confident. Sullivan nodded slightly and began what became a tough line of questioning. In your complaint, you said people at 3 different groups worked together to destroy files the government asked for. That's a big claim that could mean several national crimes if it's true. Sullivan leaned forward a bit. What proof do you have that they did this together? Crockett answered by talking about when things happened, pointing out that each group had weird responses to the same requests. She also brought up statements from people who had contacted her staff. Her answers went into detail and brought up specific rules, showing she knew her stuff, which surprised some people in the court. But Sullivan wasn't convinced. As the questioning went on, he pushed harder. Representative, weird plans and schedules might make people ask questions, but that's not proof of wrongdoing. And statements from unnamed people are just rumors. He sounded more skeptical. What real evidence can you give this court that would justify this big info request you're asking for? Crockett understood the judge's concern. Your Honor, I get that. The court needs more than just claims. That's why we filed the info requests that started this case. We're trying to get the proof that will either confirm or deny these serious charges. Sullivan's expression got serious. So, you're saying you don't have proof of the bad behavior you're talking about right now? You're asking this court to let you look for proof that might not even exist. The government lawyers at the defense table exchanged small smiles, clearly thinking the judge was leaning toward saying no. Some reporters started typing quietly, sensing that the hearing was turning against Crockett. With respect, Your Honor, Crockett replied, we have more than just a hunch. We have the AY's own answers to our first info requests, which have disturbing differences when compared to other public records. Sullivan nodded, signaling her to go on, but he still looked unsure. Crockett explained, for example, the Foreign Affairs Division said in their FOIA reply that there were no meetings between their people and agents from from other groups during the key 2 weeks we're asking about. But the guest lists from those other groups, which anyone can see, prove that Foreign Affairs Division people signed up for meetings at least 3 times during that exact period. This got Sullivan's attention, but he kept pushing. Stuff that doesn't match up, while concerning, doesn't automatically mean someone's doing something wrong. What else have you got? For the next half hour, Sullivan argued every piece of indirect evidence Crockett gave him. He questioned her closely, getting more and more doubtful, and focused on what it takes legally to make a government group show documents. He seemed really worried about the separation of powers and how much trouble he'd cause the government if he let the case continue. Representative Crockett, Sullivan said, sounding much more sure of himself, while I appreciate how seriously you've taken this, I'm worried that you don't have any real proof. You've given me a bunch of coincidences and things that don't quite add up, and that's not nearly enough to go against the respect that courts usually give government groups when it comes to their internal files. He took off his glasses and looked right at Crockett. Before I decide on the government's request to throw this out, I'll ask you one last time. Do you have any direct proof, not guessing or assumptions, that these groups intentionally hid or destroyed documents that the legislature had a right to see? The courtroom went silent as everyone turned to Crockett. The government lawyers seemed calm, clearly expecting the case to be dismissed any second. Some people started packing up, thinking it was over. Just then, Crockett said something that would change everything. I've been waiting for this my whole work life, Your Honor. She reached into her briefcase and pulled out a sealed packet that hadn't been mentioned before. Okay, so we got this evidence through a FOIA request my team filed about 6 months ago. The legal division didn't want to hand it over, but we won in court last week. Their lead lawyer went nuts as soon as he heard about it. We're objecting because all documents should have been in the accuser's filings. This feels like a cheap trick. Sullivan held up his hand to quiet them down. I'll decide if it's fair once I see what they've got. He turned back to Crockett. Bring it up here. As Crockett walked forward with the packet, you could feel the tension in the room. She gave the papers to the magistrate's assistant, who passed them to Sullivan. The magistrate started reading, and his face went from doubtful to shocked, and then to something you rarely saw on him: amazement. Judge Sullivan stared at the papers, glancing up at the administration lawyers with a look that clearly made them uncomfortable. The courtroom was silent, with everyone trying to figure out what had caused such a big change in the judge. After a few minutes of reading, Sullivan looked at the legal division team. Counselor, do you know about these documents? His voice was steady, but you could tell he was serious. The lead administration lawyer, who'd seen it all, looked genuinely confused. Without seeing what they've presented, I can't answer that, Your Honor. Sullivan nodded slowly. Fair enough. He turned to his assistant. Get copies to the administration counselor. As the lawyers got the papers, Sullivan continued, I'll give you a few minutes to look these over. The administration legal team huddled together, looking more and more worried as they flipped through the pages. Some started talking to people behind them, and their section of the courtroom filled with nervous whispers. After giving them some time, Sullivan spoke to the lead lawyer again. Now that you've had a chance to read these, I'll ask again. Were you aware these existed? The lawyer stood up, looking obviously uneasy. Your Honor, we didn't know these specific documents had been released through FOIA. We need time to talk to our clients about whether they're real and what they mean. Sullivan raised his eyebrows a bit. You're not saying these aren't real files from the organizations, are you? Not right now, Your Honor, but we'd like to double check. Sullivan cut him off. Let's be clear about what these papers seem to show. They're internal emails between top people at all 3 groups. They're talking about how to, and I'm quoting here, make sure certain sensitive things don't get to Congress. Sullivan held up one of the papers. This email from the assistant manager tells people to get creative with how they file things so they won't be found. The administration's lawyer tried to take charge of the situation. Your Honor, without context, emails like this might seem a little concerning, but concerning? Sullivan interrupted, his voice rising a little. Counselor, if these are real, these emails could prove they were intentionally blocking Congress from seeing something. It looks like the coordination Representative Crockett has been talking about. Sullivan turned back to Crockett. Representative, why wasn't this evidence in your first submission? Crockett stood confidently at the stand. Your Honor, as I said, we just got these papers last week after a special FOIA lawsuit in D.C. We got them after we initially submitted our case. I brought them here today because I figured the court would have the same worries you do about how good our evidence is. The judge nodded thoughtfully. And the administration claims they didn't know about these papers? Respectfully, Your Honor, that's hard to believe, Crockett answered. The emails include senior people from the legal division on the distribution list. The FOIA release came from their own files. Either they knew about these emails and chose not to share them with their lawyer, or their internal file system is such a mess that they can't keep track of their own potentially damaging files. Either way, it doesn't look good for their side of this case. The courtroom was silent as Sullivan considered what she said. The administration's lawyers talked urgently among themselves, clearly not ready for this development. After a moment, Sullivan addressed the court. These papers raise serious questions that can't be answered today. They give us enough reason to deny the administration's request to dismiss the case and allow limited release to continue. He looked directly at the administration's lawyers. The court is very bothered by both what these emails say and the fact that they weren't properly disclosed, even though they were obviously relevant to Representative Crockett's claims. The administration's main lawyer made one last attempt. Your Honor, if I may, even if we take these papers at face value, they don't automatically— Counselor, Sullivan interrupted, his patience wearing thin. I've been on this court for almost 30 years. I've heard every possible explanation for the administration's bad behavior. What these emails appear to be is a deliberate effort to hide information from Congress, information that several organizations were legally required to provide. Sullivan straightened the papers in front of him. Okay, here's how it's going to go. I'm turning down the administration's request for dismissal. I'm calling for a full hearing on if these documents are real. It'll be in a week. I'm telling both the legal division and Representative Crockett to give me detailed summaries. They should cover what would happen legally if these chats are the real deal. The judge paused, looked around the now silent room. I'm also requiring every group involved to give a sworn statement from their top person. This statement needs to say if they knew about these conversations and how they responded, if at all. Sullivan's voice got even more serious. These statements are under penalty of perjury. This last part clearly surprised the administration's lawyers. Making the leaders of organizations give sworn statements was a big move. It showed just how serious Sullivan thought the evidence Crockett had brought was. As people realized what Sullivan's call meant, Crockett stayed calm. The only sign she was winning? She straightened her arms a little. For the administration's team, this sudden change was a punch in the gut. What they thought was a simple dismissal had turned into maybe one of the biggest political messes the administration had seen lately. Sullivan spoke to Crockett one last time before wrapping up. Representative, while I'm letting this case move forward, I want to be clear that the court will hold all the evidence to the same high standard. Just because these papers look bad doesn't mean the court has made up its mind about the main charges. Crockett nodded respectfully. I understand completely, Your Honor. As a former trial lawyer, I expect nothing less than the court's full review of everything. As Sullivan gathered his things to leave, he made one last comment, capturing the importance of what just happened. The court notes that in our system, no group or person is above the law or beyond being held responsible. Today's hearing has reaffirmed that rule as strongly as possible. With that, he stood up and left. Amazed administration lawyers, energized legislative staffers, and reporters scrambling to file lead stories rushed to fill the void. In the audience, legal observers who had been watching shared knowing glances. They had just seen something pretty rare. A federal judge, known for being skeptical of government claims, do a complete 180 because of solid facts that even he couldn't ignore. And they watched a representative with the legal smarts to present that evidence at the exact right time for the most impact. As Crockett packed up, several colleagues reached out to quietly congratulate her. She looked professional, but there was no hiding how important her win was. In a town where political theater often overshadows what truly matters, she had just proved how powerful real evidence is in a legal fight. The effects of the Sullivan-Crockett showdown stretched beyond Courtroom 24A. By the time Representative Crockett left the courthouse, news of the explosive hearing had already spread all over Washington's legal and political circles. Within hours, the story had jumped from legal blogs to mainstream news. Judge Sullivan stuns legal division after Crockett reveals damaging evidence. Headlines flashed across news feeds. Legal experts who had initially written off the case as political gamesmanship were now scrambling to explain its potentially significant impact. For Judge Sullivan, the hearing solidified his image as a judge who follows the evidence, not politics. Commentators pointed out that his willingness to completely reverse his clear bias when presented with convincing proof showed the kind of judicial fairness that had marked his career. What we saw today was Judge Sullivan at his finest, said former federal prosecutor Rebecca Martinez on a cable news show that night. He started with a healthy dose of skepticism toward claims against government agencies, demanded real proof instead of just accusations, and then chased that proof wherever it led, even when it went against his gut feeling. That's exactly what we expect from our national courts. The way Sullivan handled things earned praise from legal experts across the government. Veteran legal analyst James Wilson said, "Even if I disagree with the final outcome. Sullivan's focus on evidence instead of political grandstanding should be standard practice for all national judges. From a progressive viewpoint, constitutional scholar Leah Thompson noted, Sullivan showed today why lifetime appointments matter. He felt free to challenge power, no matter which party was in power. Meanwhile, the legal division was in crisis mode. The revelations in Crockett's documents triggered an internal investigation, with the top lawyer appointing a special counsel to look into accusations of document tampering and blocking congressional oversight. Within days, reports surfaced that several senior officials had taken emergency leave pending the probe's outcome. Anonymous sources within the agencies described total chaos as employees scrambled to figure out how the damaging emails had slipped through FOIA requests when similar documents had been withheld before. For Crockett, the fallout brought a surge of national attention and newfound respect from colleagues on both sides of the aisle. Fellow lawmakers who had dismissed her earlier claims now sought her advice on their own oversight investigations. Legal publications ran pieces, focusing on her unique background as both a practicing attorney and a lawmaker. What Representative Crockett showed wasn't just legal skill, said legal expert Professor Daniel Cohen. It was a masterclass in strategic patience, knowing exactly when to release key evidence for maximum impact. You can't learn that from books. It comes from real legal practice. Political analysts observed that the dispute had silenced critics who had previously written off Crockett as being more interested in headlines than actual policy work. This wasn't a PR stunt, said political commentator Maria Santos. This was a seasoned litigator using her legal expertise to advance legitimate congressional oversight. The evidence speaks for itself. Beyond the immediate players, the situation sparked broader discussions about government accountability and the role of courts in resolving disputes between branches. Law schools started adding records from the case into their courses on separation of powers and judicial review. The event also changed how many agencies handled congressional document requests. Reports emerged of agency-wide memos stressing compliance with oversight requirements and warning of serious penalties for officials who tried to evade disclosure requirements. There's a before Crockett and after Crockett approach to congressional document requests now. One anonymous agency advisor told a legal publication, "No one wants to be the next example in a national court." Perhaps most importantly, the dispute set a new legal precedent for congressional standing in oversight fights. Sullivan's written opinion, released 2 weeks after the hearing, carefully outlined the criteria for when lawmakers could seek court enforcement of document requests. This framework gave a guide for future oversight efforts while still respecting traditional limits on court involvement in government disputes. Legal historians place the Sullivan-Crockett clash alongside other landmark accountability moments in American history. This case belongs with United States versus Nixon and other crucial examples, establishing that no one in government is above accountability, said constitutional scholar James Madison Williams. Judge Sullivan's willingness to follow the evidence, wherever it led, and Representative Crockett's strategic release of that evidence combined to create a truly historic moment for government transparency. 6 months after the initial hearing, as the full effects of the situation continued to unfold across multiple investigations, Judge Sullivan spoke publicly about the matter for the first time at a legal conference. Without discussing specifics of the ongoing situation, he offered an observation that many saw as reflecting on the Crockett clash. Sullivan told a group of judges that he's learned being a judge means being open to changing your mind when the facts support it. He believes the job isn't about being right from the start, but about getting to the right result by following the evidence and the law, even if that means admitting initial thoughts were wrong. The disagreement between Jasmine Crockett and Sullivan was a turning point in her career as a lawmaker. It showed she uses her legal background to get things done. In a world where politics often seems like just making noise, she proved how important real legal work and smart planning can be. Crockett said she didn't come to Congress just to give speeches, but to make a difference. Her work as a trial lawyer taught her that real change happens when you build a strong case and present it at the right time. That's how she approached the judiciary and how she'll continue to work in the legislature. The Sullivan-Crockett thing went beyond the specific people involved. It became an example of how smart planning, legal knowledge, and good timing can challenge even the most entrenched power structures when it comes to those in charge. It was a wake-up call for lawmakers trying to do their oversight jobs, giving them both motivation and a practical guide. Most importantly, it reminded people that in a system of checks and balances, facts still matter. If they are presented well and to the right judge, they can shake even the most powerful institutions. One legal expert said that in a time when political stories often seem more important than the truth, the Sullivan-Crockett situation was a return to basics, as facts, evidence, and legal reasoning won out over power, opinion, and peace. One legal expert said that in a time when political stories often seem more important than the truth, the Sullivan-Crockett situation was a return to basics, as facts, evidence, and legal reasoning won out over power, opinion, and political convenience. The image of Judge Sullivan looking surprised at Crockett's evidence became a symbol of accountability in action, reminding everyone that in the American system, even the most powerful can be held responsible if there's enough work and the right approach. If you like this look at the Sullivan-Crockett clash, please like and subscribe. We're here to bring you detailed stories about the moments that really matter for government accountability, and share your thoughts in the comments.